Hey, all you single member LLC asset protection deniers, you're going to want to watch this video because I'm going to blow up your thinking here when I report on a recent case out of Nevada when it comes to single member LLCs and asset protection. All right, let's get started. Okay, so a couple weeks back, I cut a video on single member limited liability companies and asset protection. And I got a ton of questions. And I had a lot of people that were skeptical saying, what about New York? Doesn't work in this state. And I saw another channel where they say single member LLCs, they pierce them all the time. And Clint, what you're talking about does not work. Well, when I read questions like that, you know, that you want to respond. And what really helps is when you actually find cases that back up what you're saying. So I think there was a gift that was provided to me by the Nevada Supreme Court when they recently handed down an opinion. It's called Enye versus Graham. I have the link in the show notes. It's 140 Nevada 26. It was handed down on April 18th of this year. And here's what happened. So this woman, Laura Graham, was injured when she tripped over a sprinkler box located on property owned by a single member limited liability company. Now she was injured, so what did she do? She sued the LLC and asserted that its member was the alter ego of the LLC. Okay, so meaning this, that hey, you got an single member LLC that you've set up right here. It was a Nevada single member LLC. The property's inside of here. You're right down here as that single member owner. And this gal right here wasn't paying attention where she's walking. She trips and falls, and now she's like, oh, I'm hurt. I hurt my leg. She's in her wheelchair right here, going around looking for money. So she sues this limited liability company. But the thing is, maybe that property had thin equity in it. And you're looking at it and you're thinking, hey, I want to bring a claim for $1 million. And this property has $100,000 equity. And you find out they have $250,000 in coverage there. Well, that's not enough. So here's what we're going to do. We're going to name the member of this single member LLC, bring them into the lawsuit and argue to the court that it is the alter ego of the individual, that they're one and the same. And so that's what they argued. And you know what? For all of you deniers out there about asset protection, hey, you were validated because the trial court bought off on that argument. They said, yeah, absolutely. It's a single member LLC that they're one in the same. Now, this is the thing about understanding how lawsuits work and opinions work. And when people talk about strategies and stuff when it comes to asset protection, well, when do you find out if a certain strategy works? You never find out at the trial court level because those opinions are not recorded anywhere. They're publicly available. They aren't, they just happen in this one instance. And so we can't find out about it. But it's when they're appealed, when there's a bad decision at the trial court level, that it gets appealed to the appellate court or the Supreme Court. That's when you make law. So what happened here, of course, that the owner of this single member LLC that was held to be the alter ego of the company appealed the decision, stating, hey, this is BS. I'm not liable because I'm the sole manager and member of this LLC. It's a valid company that was set up. You can't hold me responsible. That's why we set it up. So I went to the Supreme Court of Nevada, and what the Nevada Supreme Court did is they did an alter ego analysis. And this is how they pierce LLCs. And that's why there are some bad decisions. I grant you that. But when they get appealed, generally speaking, they will be respected as long as you can show that the alter ego does not exist. And so the analysis that was applied with respect to this company, actually in Nevada law, from an LLC comes from corporate law, they basically looked at three elements here. All right. And to determine whether or not a person is the alter ego of a limited liability company, you have to say the LLC is influenced and governed by the person. All right. That's one of the tests, right? So if I have a single member LLC, is my LLC influenced and governed by me? Absolutely it is. But there's three parts to this test. The second part, and this is pretty much uniform, is there a unity of interest in ownership such that the person and the LLC are inseparable? Meaning that if you look at the LLC and you look at the person, you can't tell them apart. That when you see the LLC, you see the individual. Well, in this case, she tripped on a sprinkler head, right? And the property is held by an LLC. I guarantee you she didn't even know who probably the owner of this LLC was until they decided to bring the claim. Or if they did know ahead of time, I doubt that the owner was holding out himself as the owner of the property because it's held to the LLC. Now, could you make a mistake and tell people, yeah, I own the property because even though your LLC owns it? Yeah, I could see that. That can happen, which you should take a note about this, that if you self-manage or you're dealing with tenants, never tell them you own the property. I tell people this all the time. They say, well, you're hiding the fact that you're the owner. No, I'm not. I'm not hiding the fact because I'm not the owner. It's my LLC that's the owner of the property. So possibly that could have happened. But I doubt the LLC didn't carry his same name. So it's harder to make that type of claim. So the court looked at it and said, we don't buy off on this, that it meets the second prong. And then the third prong is, adherence to the notion that separate persons would sanction a fraud or injustice, meaning this. So in this three-prong test, they not only look to see whether or not, that I just talked about, you control the LLC, whether or not you can't distinguish between the individual and the LLC, which can happen also with commingling of assets. Let's say that the individual said, hey, just write the checks to me or pay me every month, don't pay them to the LLC. But the third prong, which again is a required prong, is you have to show that some type of fraud or injustice is going to be meted out if we do not uphold the structure. Now, there's nothing in the opinion or the facts of the case that stated that this individual was creating fraud on this gal who tripped. So when Laura tripped on the box, what fraud was there? What was the guy trying to do? Intentionally harm her and then set up a limited liability company so that when he harmed her, she couldn't sue him personally? Is that the type of fraud or injustice that is being created here? I think not. So when we talk about limited liability companies, single member LLCs, understand this. They're typically a 3 or 5 prong test that they go through. And one of those elements, in every situation I'm aware of, deals with fraud. So as long as you're not out there trying to commit fraud with your company, your single member LLC should provide you protection from whatever happens inside of it. Now, on the outside, that's a different story. If you're the one that creates the harm, let's say somebody tripped in your front yard, property's in your own name, and you have a single member LLC and they want to take your interest. Well, as you know, there are certain states like Florida that hold a single member LLC interest isn't protected from your personal creditors. But from inside liability, being a single member or a multi-member should not ever make a difference in the court's analysis of whether or not they are going to disregard that form and hold you liable. Hey, this is the great part about being an attorney. You get to go through opinions like this and you get to put them out there and say, all right, see, I told you, this is the way it works. And there's more opinions out there as well. There's a recent, not a recent case, there's a case I read a few years ago out of New York. If you go back to my single member LLC video, in the comments, I posted the New York case. Similar analysis was done there. Same type of conclusion was reached. It's about the facts and circumstances. So when people tell you, hey, single member LLCs don't offer asset protection because I heard of a case where this happened. Yeah, there are single member LLC cases where the veil is pierced and people are held responsible. But you have to look at the facts and circumstances. It's not done in a vacuum. Hey guys, if you want to learn more about asset protection, how to use single member LLCs the right way, I want to invite you to my free 1-day live tax and asset protection workshop. We hold these on Saturdays. You can attend it. You're going to learn all about LLCs and corporations and land trusts and living trust and residence trusts and the tools that we use for our investing and the different strategies when it comes to using residential real estate, commercial real estate, flipping real estate, wholesaling real estate, how you tie it all together to make sure it's done a right way from an asset protection standpoint. But even better, we're going to teach you from the tax side as well. So when you're out there doing your investing, you're going to get an even greater return because we're going to teach you strategies that will put more money back in your pocket. You want to learn more? Check out the show notes because I have a link to that event in there. Register, it's completely free. And I guarantee you, you'll leave that event in a better position because I bring my team of attorneys and CPAs there to the event via Zoom. They're on there answering your individualized questions to make it a fully impact day for you. I look forward to seeing you there.